Welcome to another episode on the Law Rapport, episode 18. And today we are going to speak about identification evidence. And we will take this episode in several portions. So today we will deal with identification evidence from CCTV footage. Welcome back. Today we are going to look specifically at identification evidence in relation to CCTV footage. Now, identification evidence could be categorized as a form or a category of eyewitness evidence. And it has been proven time and time again that eyewitness evidence, second only to false confession, is the most unreliable form of evidence, and this is subject to several factors which I will deal with in a subsequent episode. Today's episode will specifically deal with identification evidence in relation to CCTV footage. With the advent of technology and the frequent use of security cameras, etc., many cases have been making their way to the courts where the bulk of the evidence, or sometimes the only evidence, the Crown relies on is evidence that come from CCTV footage. Now, the Turks and Caicos Islands has no statutory provision or any law on the books in relation to identification evidence, but we are predominantly a common law jurisdiction, and our guidance in relation to identification evidence is to be found from the many case laws handed down by the courts over the years, beginning with the case of Turnbull and the guidance set out in Turnbull. However, CCTV footage has, if you will, carved out an area for itself where identification evidence is concerned. And the Turks and Caicos Islands, having no codes of practice or guidance or guidelines for the police to follow in relation to identification evidence, we do not operate under PACE, the Police and Evidence Act of 1984. So our authority and CCTV footage is to be found, as I said before, in case laws, and even many of these case laws emanating from the United Kingdom deals specifically with the codes of practice, and in particular Code D, which deals with identification evidence. Notwithstanding that we do not have any statutory provision or guidance in this jurisdiction, best practice must prevail, and we must bring ourselves within the ambit of the best possible guidelines. And in the recent case of Jullimo Isma, that was decided by our own Turks and Caicos Islands Court of Appeal, the decision was handed down on the 4th of March 2022. The court encouraged the powers that may be to develop guidelines along the lines of Code D. And what this will do is that it would set a procedure and which the police are to follow when making an identification or recognition of a suspect and CCTV footage. And if these guidelines are followed, then a court hearing a matter that rely exclusively on CCTV footage will have something to objectively assess the reliability of the recognition evidence given by police officers. Now, the case of Jullimo Isma, it will be very helpful if I set out the factual background as gleaned from the Court of Appeal decision. Mid-morning on Wednesday, the 11th of March 2020, the deceased in this matter was shot multiple times. He succumbed to his injuries. There were no eyewitnesses to the shooting, and the only evidence connecting the appellant to the shooting was CCTV footage retrieved by the police from a camera at the resort, or outside the resort where this shooting took place. The footage on the camera captured a male walking towards the security gate at the resort. A white Honda Civic with dark tints drove up, and an unmasked male wearing a black hoodie exited the left passenger seat. He was armed with a short handgun, which he discharged multiple times. CCTV footage was viewed by 2 police officers at separate times, and both testified at first instance in the trial that they recognize the person discharging the firearm as Mr. Isma. At the close of the Crown's case, the counsel for Mr. Isma made what is known in criminal proceedings as a submission of no case to answer, arguing that based on the procedural unfairness concerning the identification of the appellant by the two police officers who gave evidence, that the identification or recognition evidence of both officers should be excluded. The judge overruled those submissions, did not agree with defense counsel, and the matter went to the jury for determination. The jury went on to find the appellant guilty. As a result, he was sentenced to 30 years in prison. He then appealed against his conviction. Counsel for the appellant relied primarily on two cases. The first case counsel relied on was the case of Dean Smith and others against the Queen, 2008, a case that was decided by the United Kingdom Court of Appeal. And second, the case of Jake Seaton and the Queen. And counsel relied on paragraphs 67 and 68 of the case of Dean Smith and others. And the court, it would appear from the written decision, found this case to be persuasive. And I will read paragraph 67 and 68 of that case for completeness. 67. A police officer asked to view CCTV is not in the same shoes as a witness asked to identify someone he has seen committing a crime. But as the prosecution accepted, safeguards which the code is designed to put in place are equally important in cases where a police officer is asked to see whether he can recognize anyone in a CCTV recording. The mischief is that the police officer may merely assert that he recognized someone without any objective means of testing the accuracy of such assertion. Whether or not Code D applies, there must be in place some record which assists in gauging the reliability of the assertion. In cases such as these, there is no possibility of comparing the initial observation of a witness as recorded in a contemporaneous note of description or absence of description, who purports to make a subsequent identification. The police officer can hardly be asked to record his collection of a description of a particular suspect before he has picked that suspect out from the CCTV recording. Section paragraph 68. Absent any such checks as would be available had a witness described the commission of an offense and recollected his description of the offender, it is important that the police officer's initial reaction to the recording are set out and available for scrutiny. Thus, if the police officer fails to recognize anyone and the force of viewing, but does so subsequently, those circumstances should be noted. The words that the officer uses by way of recognition may also be of importance. If an officer fails to pick anyone else out, that also should be recorded, as should any words of doubt. Furthermore, it is necessary that if recognition take place, a record is made of what it is about the image that is said to have triggered the recognition. So, this case of Dean Smith, which was decided by the United Kingdom's Court of Appeal, is focused, paragraph 6760 is focused on the fairness of the proceedings and how the trial of facts, whether it be a judge alone trial or a trial with judge and jury, how are they going to assess the reliability of a police officer who says, I recognize the person and the CCTV footage to be X, Y, or Z, if there is no record. So at the time when that officer is viewing the footage, he ought to be making notes pertinent to his recognition identification. And I will not go into all the nitty-gritties of what should be done and what's not to be done. But the officer would be well served to make a full and detailed record so that at the end of the day, the court will trial facts or of law will be able to assess the circumstances of recognition and so protects the defendant's right to a fair trial. And the defendant's right to a fair trial is an absolute right. So the appeal against conviction, in this case, the case of Jullimo Isma, surrounded the fairness of the trial, that the trial judge should not have allowed or admitted the recognition evidence from the police officers into evidence, and that his summing up of the trial was unbalanced, and overall the defendant did not receive a fair trial. Now, the Crown was represented by the Deputy Director of Public Prosecutions, conceded that there were no contemporaneous notes that were made, conceded in essence that the police officers did not do what they are to have done in relation to identification from CCTV footage. She also argued that PACE and the Code D was not part of the laws of the Turks and Caicos Islands. The Court of Appeal did not find this argument to be persuasive at all, and the court went on to hold that the conviction was unsafe and directed an acquittal in the matter. The court concluded at paragraph 48 when it says, in light of the foregoing and having regard to the submissions by counsel for the appellant, we were satisfied that the appellant did not get the benefit of a fair trial. Accordingly, we allow the appeal, set aside conviction, and direct an order of acquittal to be entered. And the court carried out an in-depth analysis of the whole trial process and the identification evidence. And at paragraph 33, the court said the following: the trial judge's direction would have been sufficient had the safeguards been followed. The importance of a contemporaneous record of the viewing of the footage is necessary to enable the jury to make any meaningful assessment of its reliability. The Crown had submitted that the directions given to the jury by the judge or the trial judge were sufficient to mitigate any breaches in the procedure in the identification process. The court was not moved by those submissions. Further, as I stated previously, the court went on to recommend that the Turks and Caicos Islands should develop some sort of procedure in line with Code of PACE. And this is very significant because in a very recent case that was decided at first instance in the trial of Derrison Music, counsel for Music made identical arguments where an officer purported to recognize Mr. Music from CCTV footage, and there were serious procedural irregularities in terms of the procedure that are to be followed, and counsel in that matter also relied on the case of Dean Smith, and this very case, the case of Jullimo Isma. and the judge on that occasion excluded that identification or recognition evidence. And once that evidence was excluded, the Crown had no choice but to discontinue the matter against the defendant because there was no other evidence to support the very serious charges before the court. The officer cannot neglect to follow the procedure and then post facto, after the fact, try to justify the reason for their recognition and identification. They are to set out in clear terms how the recognition came about so that the court and defense counsel can scrutinize that process in order to assess properly on an objective basis the reliability of that recognition. Any failure to do so, in my respectful view, would render any conviction unsafe, or would run the risk that at first instance that evidence will be excluded, and if there are no other evidence to support the charge, the Crown, as was the case of Deresu Mizik, may have to discontinue their case. This is where I would leave it for today. If you find anything in this episode that you would have liked or that wasn't clear, please leave a comment and I will clarify. I will see you in another episode when I expand further on identification evidence and other categories or aspects of identification evidence. Thank you.